Morning. My name is David Heidt. I teach at the Carrollton School of the Sacred Heart, and I am going to give you the opening topic lecture on the water topic. So welcome to the Michigan Debate Camp. After this lecture, I will be available to answer questions live, although I'm recording this the day before. So my lecture is basically three sections. I'm going to be talking about topicality, and then I'm going to be talking about significant laws that are relevant to water policy, and then I'm going to actually talk a little bit about the structure of water rights in the United States and how I think that intersects with the topic. So I think that the topic is a decent topic. The body of literature for it is pretty interesting. There was a previous topic in 2003 that used the phrase increasing protection of marine natural resources. That was an oceans topic. This topic specifies in the United States, so it is very likely not an oceans topic, whereas the previous two oceans topics, they said they did not have the qualifier in the United States, and that is relevant. So the two terms I'm going to be talking about here are water resources and protection, in terms of how I think that you should think about what the topic actually means, because the protection is extremely well defined, as is water resources, but there's a lot of disagreement over various interpretations. I do think the topic is very broad, and that I'm not convinced that topicality is going to play a huge role next year, but I do think that there are at least some arguments that some things that protection very likely does mean that will help you think about the topic as a whole. So the first thing is water resources. And the United States Department of the Interior has something that they call the U.S. Geological Survey, or the USGS, and they conduct a water census according to congressional legislation, where they are in charge of surveying all water resources in the United States. That's their goal, their mission statement of the water census. Having said that, they don't explicitly define what water resources mean, but these are the types of things that they actually use in the water census itself. So river basin inflows and outflows, surface water storage, groundwater reserves. That's the bulk of what constitutes water resources in the United States. So river basin inflows and outflows are just rivers and streams. Surface water storage might be lakes, but also reservoirs, things that are dammed, anything, water towers, things like that all constitute surface water storage. Groundwater reserves is everything below the ground. Of all the water in the world, there's about 2.5% of it is fresh water, which is primarily what we're talking about with these first three categories. And freshwater resources, 0.5% of freshwater resources is in surface water storage. So is in surface water period. So in like in lakes, rivers, streams, all that constitutes about 0.5% of all freshwater resources in the world. Groundwater reserves constitutes about 30% of all freshwater resources, and the remaining 70% is all in snow and ice. Is a way of storing water, I suppose. Brackish water is not, it's hard to see on this particular graphic, and I'm not sure if you can see my cursor or not, but the brackish water is essentially a mixture of fresh and saline water. And so it's typically brackish water is in an estuary where stream meets the ocean or river meets the ocean, or it could be in wetlands or in marshes. And that is definitely included as a water resource under the U.S. Geological Survey. That's part of surface water. Saline water is salt water, which the U.S. Geological Survey also includes as part of water resources. Wastewater is just water that's been polluted or used for a particular purpose, but can be reused potentially in some industrial applications, and therefore also technically constitutes a water resource. In terms of formal definitions, so I have a few for you. The National Research Council has a definition that I think is pretty good. Like Congress commissioned them with a report to study all water resources research in the United States. And for the purpose of that particular study, they defined water resources as fresh and brackish water in the atmosphere, streams, lakes, unsaturated zone, aquifers, and estuaries. Now, the U.S. Geological Survey does not count atmospheric water as water resources, whereas this particular definition does. They're probably equally qualified, given that both were charged with Congress to come up with like a very similar thing. This particular definition does not include saline water as part of it, but does include brackish water because it includes estuaries. But saline water is probably included under the definition of water resources. And then the United Nations has like an actual limiting definition of water resources, where I think that this is pretty important because it says that water resources are defined as the water that in fresh and brackish surface water and groundwater bodies within the national territory. The water of oceans and open seas is excluded on the grounds that the volumes involved are so enormous as to make any stock measure meaningless, and the extraction for human use has no measurable impact. So there are three things to note of this particular definition, which I think is very useful to think about the topic. First is that it doesn't include saline water as part of the definition. So maybe the ocean is just like excluded outright. Second is it does say that within the national territory. So that implies that all surface water and groundwater within the territory of the United States, so in the United States, might be topical. And then it excludes the water of the oceans and the open seas, but doesn't necessarily exclude the coast, which is within the national territory of the United States. So I think this definition is very good because it is a limiting definition on a topic that is extremely broad. And if the topic is not about the oceans, then it actually gives this topic kind of a unique meaning and a unique body of literature distinct from the previous two ocean topics that the debate community has debated. And it definitely involves like a considerably different literature base. I do, however, want to talk to you a little bit about the difference between the territory and the open ocean. So this particular, this particular graphic divides the ocean into specific zones, some of which might be topical under the United Nations definition and others are clearly not. So the Territorial Sea is the sovereign territory of the United States. That means that under international law, that counts as like part of the United States, where the United States exercises full sovereignty, owns the land, owns everything about it. Anything that happens up to 12 miles off the coast of the United States counts as happening in the United States. It extends 12 miles out. The first 3 miles off the coast are controlled by states and are considered part of states. The area between 3 and 12 miles off the coast is controlled by the federal government, with the exception of the west coast of Florida, and for Texas and Puerto Rico, up to 9 miles of the Territorial Sea belongs to those particular local jurisdictions and not the federal government. The Contiguous Zone is an area where the US has the ability to enforce some regulations. It's not considered part of the territory of the United States, but the US still exercises jurisdiction over that area. As it relates to the topic, the US enforces anti-dumping laws in the Contiguous Zone, and then the Exclusive Economic Zone is where the United States has the right to develop and regulate resources within that area. And significantly, the Clean Water Act, which is the primary law that governs water pollution in the United States, applies throughout the Exclusive Economic Zone, in addition to just the Territorial Sea. So if the affirmative is going to try to make an oceans affirmative topical, they would probably have to define the US Geological Survey as including saline water from the oceans, which it definitely does. They would probably have to say that the territory or in the United States constitutes any area within US jurisdiction as opposed to the actual territory of the United States. And they would probably say that the Clean Water Act applies to the Exclusive Economic Zone. Having said that, I am skeptical that the affirmative will reliably win this argument, just because from a limits perspective, including the Exclusive Economic Zone would make this topic very much the equivalent of the previous two oceans topics, plus everything related to domestic water resources. So like just a massive topic. And the fact that there is a pretty strong exclusive definition that excludes at the very least, the Exclusive Economic Zone, I think bodes well for the negative in terms of thinking about this topic as excluding the ocean. Okay, so the word protection is a complicated definition. There are dozens of definitions in the context of water resources that talk about protection. And they're so good that I would say that any definition of protection that is not in the context of the topic is probably just flat out unusable, simply because there's so many contextual definitions that I think that the team that defines the term contextually is going to have a strong advantage. The first, I'm going to talk about 3 interpretations of the word protection. There are definitely more than that in the topicality file, but I'm going to talk about what I think are like probably the 3 most useful ways to think about the topic. So the first, and what is like probably represents capital T truth in terms of what protection means, is protection means preventing adverse impacts on water resources. And you can kind of think about that as reducing water pollution, but it could be things other than water pollution too. It's like preventing any adverse impact on the water resource itself. So potentially threats to the sustainability of water resources, such as overuse, might fall within that definition, or it might not, depending upon the evidence that you use. I have 3 cards that support this argument. The first is from the Environmental Protection Agency. The problem with this definition is that it doesn't define it in the context of water resources, but it does define it in the context of just resources. And it seems this is probably the most accurate interpretation of what protection means, just the safeguarding of resources from harm. There are several other governmental agencies, such as the U.S. Department of Agriculture and the U.S. Department of the Interior through the Bureau of Land Management. They define protection in a very similar manner that in the Bureau of Land Management defines it in the context of water resources itself. A second definition from the EPA that's like similar to what I just showed you, but it is about water, but only about water quality protection as opposed to water resource protection. Says that it's procedures to guard the health of the chemical, physical, biological, radiological, and other properties and characteristics of the water. So something that probably prevents the pollution of the water from contaminants, and it lists the types of contaminants that might exist. There's definitely an interpretation of the topic that says that protection of water resources is really only about water quality. So maybe this is a controlling interpretation, but it's not perfect because it doesn't actually define it in terms of protection of water resources. A third definition, which is from the World Bank, which I think is this is like probably my favorite definition of the topic. Like there are like a lot of cards that say the same thing, but this is from the World Bank, and it's a World Bank study of a comparison between 16 different countries, including the United States. So like, even though it's from the World Bank, it does actually include a study of US law when it derives this definition. And I like it because it actually says protection of water resources as a phrase, which it defines as preventing pollution. So protection of water resources includes the prevention and abatement of both point source pollution and diffuse pollution, regulation of discharge of wastewater and other wastes, regulation of land use, particularly land cultivation practices, and adoption of detailed procedures for enforcement of water quality standards. So this introduces, I think, 2 terms that you need to know. So point source pollution, and then what it calls diffuse pollution, but the EPA calls non-point source pollution. The difference between those 2 things I'll show you is on this particular graphic. So point source pollution is from a specific source that is dumping something into a waterway. So the factories here are point sources, whereas non-point source pollution is pollution that comes from just runoff in, like when there's a storm and stormwater causes runoff into a waterway. It washes all of the pollution that we just happen to have on the land into the water. So non-point source pollution includes agricultural pesticides, which is why this particular definition that says regulation of land cultivation practices is about protection of water resources, because it is, because the #1 source of non-point source pollution is actually fertilizer pollution from farmland. It includes, just like animal waste from concentrated animal feeding operations, which are regulated by the Clean Water Act. So you can see all this livestock, when they poop and the water washes it, or rain washes it into a water source, that causes bacterial contamination of a water source. And than just like, chemical pollution from lawns or streets, or, all the things that we use in industrial society, make their way into the waterway. Plastics, for example, and all of that constitutes non-point source pollution. So if you're thinking about point source pollution, it's the act of like deliberately dumping something into the water, or even if it's not deliberate, it's just like, something that comes from a particular source that could be controlled. And non-point source pollution is, kind of more general pollution that happens to go into the waterway. And as US law mostly regulates point source pollution and does not do very much for non-point source pollution. Second interpretation of protection would be that protection is not conservation or management of water. So this is an interpretation that would say that affirmatives that regulate the use of water, so the overuse or overconsumption of water that contributes to a water crisis, those affirmatives are not topical because they are conservation and management and not protection. And this particular card I made a lot shorter for the purpose of the PowerPoint. It's a much longer card, and it's quite good, which does say that, to protect an estuarine resource, which is a type of water resource, means to regulate or prevent conflicting uses from affecting the resource in a significant way. It means inhibiting the development that causes significant adverse impact on the protected resource. And then the important part, by comparison, maintain is to support, keep, or continue in an existing state, and conserve means to manage in a manner which avoids wasteful or destructive uses and provides for future availability. And that essentially protection means the regulation of activities external to the property itself. So the regulation of things that affect the water, whereas conservation might be the regulation of use of the water. I don't know that this is the best argument. I feel like in terms of like how the majority of the literature treats water protection, they would definitely include conservation and management of water resources as part of that, because the two significant threats to water resources are overuse and pollution. And if you look back at the EPA definitions, at least that first definition, of which there are many definitions along those lines, it doesn't say stop pollution, it stop harmful activities. And there's a lot of overlap between that. There's a lot of evidence that says that overuse of water resources threatens the viability and sustainability of that water as a whole. It could destroy a water ecosystem. So I'm not sure how successful the negative will be in terms of limiting out affirmatives that try to manage or stop consumption of water. I think the negative will try. I do think that the balance of the affirmative evidence for this is, however, quite strong. A third interpretation might be that protection means regulation, and ideally for the negative, a specific type of regulation, which is command and control regulation, which basically says that the government tells the industry to stop polluting or reduce pollution to a particular level, and the industry has no choice in terms of how they can comply. And there's really only one definition that I've come across that supports this interpretation, which is this card, which on the 2003 oceans topic, which also used the word protection, this card was responsible for single-handedly winning a slew of debates. And this card is quite good. It says UN Close, which is the UN Law of the Sea Convention, the UN Convention on the Law of the Sea, creates the obligation to protect and preserve the marine environment. There is little difference between conservation and preservation in the context of protection. However, conservation connotes a conservative use of a resource, but a use nonetheless, while the term protection is used to command a cessation of use. So there are two important things going on here. So one is this evidence says that protection is not conservation, that protection means to stop using something. And two is it's the only card that I've seen on the topic that says protection is to command a cessation of use. So it implies that it's a form of command and control regulation, a regulatory command. That's significant because there are a lot of different forms of regulation. There are regulatory incentives, for example. So if the negative just wants to say that protection means regulation, there's a lot of other evidence that supports that interpretation. But the problem with that is that the term regulation itself means a lot of different things. And there are market-based regulations and there are command and control-based regulations. And when the negative says that the affirmative team should regulate the use of water resources, they really mean the affirmative team should involve command and control regulations. And that is, I think, you know, the ideal world for the negative, is that they could kind of win this particular interpretation. Having said that, this card is not actually very good. There are a lot of problems with this card, and like it arguably applied on the 2003 topic, it probably does not apply very well on this particular topic. You know, the first problem is that, you know, the author is just an unqualified law student, and she's making an argument about the UN Law of the Sea Convention, where she kind of implies that protection has a specific meaning under the Law of the Sea Convention, and factually it does not. The Law of the Sea Convention does not define the word protection, and in fact uses the word protection in the context of sustainable use. So just like as a factual perspective, this card is like definitely wrong and very unqualified, and there are a lot of cards that contest this that are better. The second problem is that a cessation of use in the context of water resources does not make very much sense. The author is writing this in the context of a whaling convention because she wants the UN Law of the Sea Treaty to ban whaling as opposed to allow some whaling. And that like sort of makes sense in that context. It makes no sense in the context of a water resources topic where society requires water to function, but it does not require whaling to function. So to me, this card is like not very good, but I do think that it is probably the best card that supports the notion that protection is a form of command and control regulation. I do think that the negative will really try to win that argument. I am not convinced that the notion that protection even means regulation is actually winnable. Like the federal government has programs it describes as protection that do not involve regulation. And that to me just seems to like destroy this argument. But at the same time, you know, there are definitely good cards that say that protection involves regulation. I'm just not convinced that that's what the topic actually looks like. So when I think about topicality on this topic, I do think that the topic is very broad, and the core meaning of the topic, which is to prevent an adverse impact on water resources, the thing that is like, you know, defended by a million qualified contextual cards that are like probably better than what most of the cards in the negative could read say, those cards do create an enormously broad topic. And they do that in two ways. So like the first way is just like, what does it mean to like prevent pollution? There are a lot of things that pollute the water. And, you know, like a lot of things we can think about just like dumping into the water or agricultural runoff, which is like probably the largest water pollutant. But there are other pollutants that are a little bit counterintuitive that don't directly involve the water at all. And it's possible that maybe an affirmative team could write a plan that has nothing to do with water, but does have an effect on water resources. And like under most topics, we would say that that is effects topical and therefore not legitimate. But on this topic, if that's what the word protection means, then that does potentially create a very expansive topic. So to give you two examples, on the college 1997 topic, which was about regulating environmental pollutants, there was an affirmative run by Emory University that essentially banned tritium production, which is a radioactive element that is used for the manufacture of nuclear weapons. And all of their advantages were that if you stop tritium production, because tritium pollutes the water, then you would stop the modernization of nuclear weapons. And the entire advantage of the affirmative was about nuclear disarmament. As another example, uranium mining also pollutes the water. It is done on federal lands. It is possible to potentially regulate or ban uranium mining and claim a similar impact, or potentially, you know, like that has been an affirmative that has been run before as something that kind of uniquely harms Native American populations. And then as a third example, there's a lot of evidence that says that air pollution causes water pollution, and especially climate change causes water pollution. And there are cards that definitely say that you know, regulating air pollution is a way to limit water pollution. Now, will the judging community think that those AFs are topical? Probably. I think they'll probably, you know, be hesitant to vote on that set of arguments. It is, you know, maybe topical to regulate the levels of tritium in the water supply, but it seems probably not topical to just ban tritium production itself. it is maybe topical to regulate the amount of sulfuric acid that, goes into the water supply, and maybe that requires limits on air pollution, but it's probably not topical to just like ban air pollution itself. I'm not sure. Like I said, I do think that it is a broad topic. I do think that a lot of things constitute water pollution, and I think that the question of effects topicality will be very relevant on this topic to a way that it has not been relevant on previous topics. Okay, so the next thing that I'm going to talk about is the regulatory framework for water protection. We're going to talk a little bit about laws, but I think that it's useful to think about the topic in terms of two sections: water quality and water use. So water quality are affirmatives that would try to limit the pollution of the water, and water use would be affirmatives that try to limit the overuse or overconsumption of water resources. And I think that those two things are, on one hand, flip sides of the same coin, because overuse of water undermines water quality, which is why I'm skeptical that topicality arguments that say that conservation is not topical are going to be successful. They might be. Some of the cards are pretty good, but I'm still skeptical simply because overconsumption of water resources definitely undermines water quality. But if you think about them as two different concepts, I think it's important to think about them in those ways, because different sets of laws govern each concept. So if you think about the topic as water quality, the two primary laws that affect the water topic or water regulation are the Clean Water Act and the Safe Drinking Water Act. There are definitely other laws. So there's like the Wild and Scenic Rivers Act. There's the Act to Prevent Pollution from Ships. There's like the Beach Act, which prevents like dumping on the coasts. There are a handful of other laws too. There's like one law, CERCLA, which affects solid waste, but that solid waste can be dumped into the water, so it definitely overlaps with it. There's the Endangered Species Act, which governs waterborne species, and pollution sometimes could be involved in that too. So there's a big framework of laws, but the two laws that primarily that govern like almost all water pollution are the Clean Water Act and the Safe Drinking Water Act. And the other laws that I've described are like questionably topical, if the topic is about stopping water pollution or threats to water resources itself rather than things that live in the water. And like maybe the Wild and Scenic Rivers Act. That's a separate law governed by the Department of the Interior, but probably also would be topical. It's just like a much less body of literature, so I'm not really going to talk about it today. And then the legal framework governing the use of water is determined by water rights, which is very complicated and mostly exists at the state level. But I'm going to talk about that at the third section of my lecture. And like the strategies that you would need to talk about this from either the affirmative or the negative perspective are a little bit different if you're talking about the legal framework for regulating water pollution versus the legal framework for regulating the use of water. I think knowing about both of those things is pretty important to understanding the topic. Okay, so the Clean Water Act, the official name of it is actually the Federal Water Pollution Control Act. It was passed in 1948. It was not very effective in 1948, did not really have an enforcement mechanism. The Environmental Protection Agency did not exist in 1948. It didn't really come into existence until the Nixon administration. And then it was amended to become known as the Clean Water Act in 1972. And a lot of the political push behind those amendments was because this river, the Cuyahoga River in Ohio, was on fire, and that captured the public imagination. It was, it caught on fire, I think 11 times overall, and this particular picture is like of the largest one. And this picture occurred much earlier. There was like a much smaller fire that occurred in the late 60s that somehow captured the public imagination. They were like, our water is terrible because our rivers are literally burning because there's so much industrial waste dumped into this river. And this river, like, the thing that was responsible for this particular fire was a steel plant that was like dumping toxic chemicals into the water. And it was so bad that if an employee fell into the water, they immediately had to go to the hospital because they could die from all the pollution, and so bad that it literally caught on fire. So the Clean Water Act sets water quality standards for point source pollution in surface waters of the United States. So there are two like pretty big emissions here. It does actually affect non-point source pollution, which I'll talk about eventually, but it does not set water quality standards for non-point source pollution. It only regulates like the regulation component of the Clean Water Act applies to point source pollutants only. And it only applies to surface water. It doesn't apply to groundwater for the most part. So like this picture is of a point source polluting the water. And that's how you should primarily think about the Clean Water Act. The Clean Water Act defines pollutant, and I included this definition up here mainly because I want you to think about two things that you might not necessarily think about as pollution that count as pollution on this topic. One is heat pollution. So a dam that dams up a river and therefore heats the temperature of the water that is dammed up technically counts as heat pollution, according to the EPA. A power plant that is a thermoelectric plant, which means they basically take an enormous amount of water and then they turn it into steam to produce electricity. And then when that steam returns to water, it has like some pollutants in it, and they release that back into the waterway. That is released at a much higher temperature, and that pollutes the water because it alters the chemical properties of the water. It makes it much harder for things to live in the water to actually keep on living as a result of heat pollution. The other thing to think about is dirt, rock, sand, dirt. So sediment pollution is something that's counted under the Clean Water Act as a pollutant. So if you dump sand into a water, or if a dam accumulates an enormous amount of of sediment, that pollutes all the water that's around it because it makes it harder to drink that water or for fish to live in it and things like that. The Clean Water Act also defines a point source, and this is relevant. So it basically defines it very broadly. So any discernible, confined, and discrete conveyance. So something that is a discernible conveyance of pollutants. So as distinct from a non-point source, you can't determine exactly where that pollution came from, but with a point source, you can. Here it's the pipe that's dumping things into the water. So there is a little bit of overlap between stormwater, which is generally considered non-point source pollution, and regulation of a point source. So for example, a stormwater drain that's at a construction site that involves a lot of possible pollutants, and that stormwater that drains into a particular water source, that could be considered a point source, even though normal stormwater that isn't directed to go somewhere would be considered a non-point source. The other thing that is here that is like very relevant is that its definition of a point source pollution explicitly exempts agricultural stormwater discharges and return flows from irrigated agriculture. So there is an agricultural exemption within the Clean Water Act for coverage of point source pollution, which is pretty significant because agricultural stormwater discharges are the #1 source of freshwater pollution in the United States, and it is exempted from the Clean Water Act, very explicitly. So I think that's relevant. And then for a non-point source pollution, the Clean Water Act doesn't explicitly define that, but EPA regulations define it as any source of water pollution that doesn't meet the legal definition of a point source. So non-point source pollution is everything else. It is important to remember that the Clean Water Act itself does not directly regulate groundwater. So there are like non-point source pollutions and source pollution for groundwater that are not really covered by the Clean Water Act. In terms of the scope of water pollution in the United States, this picture is of a boat off the coast of California sailing through a green algae bloom, which is from California's agriculture, from nutrient pollution runoff that basically chokes the life out of the water everywhere it is, because there's so much algae that it sucks up all the oxygen from the water and causes everything else under the algae to die because they lack oxygen. and create something called a dead zone. So in terms of like the #1 source of water pollution in the United States, it comes from power plants. It is not the #1 source of fresh water pollution because a lot of power plants don't use fresh water, but a lot of them do. And about 50 to 60% of all water pollution in the United States comes from wastewater from power plants. And there we're, in part talking about heat pollution. We're also in part talking about things like coal ash. So a coal plant that, it discharges a bunch of waste, they send that into the water supply. And the Supreme Court ruled that the coal ash was not subject to EPA regulations because coal ash ponds were not part of the waters that were covered under the Clean Water Act, even though coal ash ponds do create non-point source pollution water when they like overflow and send coal ash into the rest of the water system. Agriculture is the #1 polluting source for fresh water. That includes nutrient pollution from fertilizers, which is about 20 million tons a year of phosphate and nitrate pollution that causes algae blooms and dead zones. There are about 1 billion tons a year of animal waste from concentrated animal feeding operations, which is definitely an affirmative. It's something that's regulated by the Clean Water Act. There was an AF on the college agricultural subsidies topic to ban subsidies for CAFOs. On this topic, you probably couldn't do that, but you could definitely regulate the waste emissions from CAFOs. You could probably regulate them so strenuously that it would cause them to shut down. They also cause like antibiotic and hormone pollution. So they send antibiotics and hormones given to livestock into the water supply because their poop, involves those hormones, and then it goes into the water supply and then you drink it. And then there are about 191 million pounds of chemicals dumped into the water each year from industrial sources. And this is a slightly different issue because it's governed by a different law, the Safe Drinking Water Act. But 30 million people in the United States live in areas where water systems have violated EPA safety rules. That particular statistic changes year to year because as some water systems come into compliance and some water systems fall out of compliance. And then 2 million people in the United States just lack access to running water, period. They don't have a safe drinking water source at all. That usually primarily affects communities of color and especially Native American communities, very rural communities that don't have access to like a public water supply. And then about half of the rivers and streams in the United States are listed by the EPA as in poor condition, which is their lowest rating. So poor could mean a lot of things, but it essentially means that the water is not safe to drink. The water is potentially a public health threat. The water is a source of like bacteria pollution, and you should definitely not swim in them unless you want to get sick. Okay, so the Clean Water Act, the way it regulates point source pollution is pretty important because the Clean Water Act, the primary thing it does is regulate point source pollution. It is kind of complicated, but you do have to understand the process to be competent on the topic. So Section 402 of the Clean Water Act establishes something called NPDES, which is the National Pollutant Discharge Elimination System, and is the primary way the EPA regulates point source pollution. And what that is a permitting system that does not say you can't pollute, you can't dump things into the waterway. You can, but you have to have a permit to do that. So like this particular political cartoon is just of like people dumping things into the water, and the EPA is like okay with that as long as it meets EPA safety standards. So the Clean Water Act does not say people can't pollute. The Clean Water Act instead says people can only pollute within safe levels, within levels that it doesn't affect public health or public safety, and basically like the theory is that the overall natural resilience of the water system will diffuse that pollution and make it no longer a problem. But like some pollution is okay. So the EPA issues water quality standards. They hire scientists, they decide like what is the acceptable level of pollution. They will, grade that based off of like, does it advert, does a level of pollution that might not normally affect the public, does it have an adverse effect on older people or on pregnant women or like different risk groups? They conduct a cost benefit assessment of just like, how costly is it to eliminate this pollution? What are the benefits of lowering this pollution? Or, what is the ideal public safety level for the level of pollutants in the water? And then they establish those standards, and they will issue permits that allow people to pollute as long as they fall within those standards. And then if you pollute without a permit, or if you exceed the amount of pollution that you're allowed to pollute based off the permit, then the EPA does compliance monitoring. So they like send out inspections to see how much each company is polluting the water. They will issue fines if you're in violation, and they will give you issue an obligation to clean it up. And if you don't clean it up, then potentially you could face criminal consequences, but mostly this is enforced through civil fines. And then the other part of the Clean Water Act related to point source pollution that is very important is Section 404, which establishes a permitting program for dredge and fill material into the waters of the United States. So this picture here is hopefully helps you remember what Section 404 looks like, because it's about like construction projects that occur within the water to basically change the character of the water. It covers permits for infrastructure like bridges, airports, dams, mining. If somebody wants to like destroy the wetlands and replace it with like a strip mall, that would be governed by Section 404 of the Clean Water Act to determine whether or not that was permissible. So essentially the EPA sets water quality standards that constitute like the acceptable amount of dredge and fill material that go into waters of the United States. It exempts farming and forestry activities related to dredge and fill material. So that means like, if you build a farm road or a forestry road that would involve dumping a bunch of stuff in the water, that's perfectly okay, because in theory, like that, that forest has water quality benefits, and forestry practices offset that according to the government. And the important thing to remember for this, and this is the main reason why I'm including this, is that the Section 404 is run and enforced by the Army Corps of Engineers. So there are many significant agencies involved in this topic. I did read a card that said that there are like at least 20 federal agencies involved in enforcing water quality standards in the United States. But the primary one is the Environmental Protection Agency, and the next most important one is the Army Corps of Engineers. And that's because the Army Corps of Engineers oversees most infrastructure projects, or at least infrastructure projects that involve the federal government in the United States. And they are in charge of the Section 404 permitting program for the Clean Water Act. Now, the EPA still sets the water quality standards that Section 404 is governed, so the EPA is still involved in the process. And the Army Corps of Engineers sends its reports about permitting to the EPA, so the EPA can review them. So if they didn't like it, in theory, they could talk to the Army Corps of Engineers. But the agency that actually implements Section 404 of the Clean Water Act is the Army Corps of Engineers. So if you're reading an AF about wetlands, you're probably mostly talking about the Army Corps of Engineers. If you're reading an AF about dams, you are probably talking about the Army Corps of Engineers or the Department of the Interior, which I will cover in the next section. So the next thing I wanted to talk about for the Clean Water Act, especially as it relates to point source pollution, is the role of the states, which I think is vitally important to understand for this topic. Because the reality is the state's counterplan probably solves like the vast majority of all affirmatives. It's not like as grim as I'm necessarily portraying it, because there are very good federal key cards that answer a lot of the arguments that the state's counterplan is designed to answer. But the states have an enormous role in enforcing basically all federal water quality and federal water use standards in the United States. And will probably be like the #1 negative generic, or should be the #1 negative generic, is probably the state's counterplan. So the Clean Water Act itself only applies to navigable waters of the United States, because water is treated by the Supreme Court as an article of commerce, and the thing that gives the Congress the authority to regulate the environment is the Interstate Commerce Clause in Article 1 of the Constitution. And essentially all federal authority stems from this. So for like every federal water pollution regulation stems from the Commerce Clause. And outside of the Commerce Clause, the states are basically fully in charge of what they do with the water within their state. Now, the reality is like almost all water has an interstate component, but for projects, for water resources that are purely intrastate, so water that is purely within one state's boundaries, that is completely governed by state law. And even for interstate water, states generally govern the water that is within their particular state. So between Georgia and Tennessee, they have like water fights over like who accesses their water all the time. And like Atlanta faces a drought and has like a severe water crisis and gets a lot of their water from Tennessee. Georgia regulates all of the water that is in the Georgia portion of that, even though that watershed is shared jointly by Tennessee and Georgia. And Tennessee regulates their side, and they try to work out conflicts between them through interstate compacts. And what that means is that even under federal law and even under the Clean Water Act, states retain primary authority over water quality standards. So essentially what this means is the Clean Water Act through the EPA sets federal minimums that states have to adhere to the minimum standards that are established by the Clean Water Act. But if there are federal exemptions within the Clean Water Act, then states can fill in those exemptions. So like the Clean Water Act doesn't apply to agricultural water sources. There's an express exemption, but state governments could exceed the Clean Water Act protections by adopting their own protections for agricultural water quality. So states do have the primary authority to regulate. They can't go below the federal floor, but there is no federal ceiling. States can exceed what the EPA says is a safe level. States can do that a little bit more. Section 101B of the Clean Water Act, in fact, authorizes states to administer Section 402 and Section 404 of the Clean Water Act. So even though those sections are overseen by the EPA and the U.S. Army Corps of Engineers, states are the ones that actually do almost all of the work on the ground. And the way that the EPA oversees it and inspects it, it's not that the EPA has like a huge enforcement division. It's actually state EPAs have their own enforcement divisions, and they send reports to the federal EPA about this. So states are like heavily involved in that. Section 401 of the Clean Water Act allows states to override EPA and Army Corps of Engineers certification if they don't comply with state water quality standards. So if the EPA is like, sure, you can go ahead with that project, it doesn't really threaten water quality, and the EPA produces something that's awful because the EPA standards are too low, the state governments could just say, no, we're going to override that certification. We're going to, even though you were approved to go ahead with that level of pollution under Section 402 of the Clean Water Act, the state government can just say, yeah, too bad. It might be okay for the federal government, but it's not okay under the state government. Now, having said that, the Trump administration, because it was the Trump administration, did have a rule that basically narrowed the scope of Section 401 to prevent states from doing that. So if the federal government gave approval, then the states couldn't do it because the Trump administration was like very opposed to the environment. But the Biden administration has, decided to rescind that rule. So this is or will be, when the rule change takes effect, states will have the authority to veto Section 402 and Section 404 permits, to like deny certification, even if the federal government approves that certification. And then the other thing is that states retain exclusive authority over non-point source pollution. And the biggest problem in water pollution in the United States is not point source pollution. The EPA, at least pre-Trump EPA, was like doing an okay job of point source pollution. The non-point source pollution is almost entirely unregulated. And states have the authority to do that within their territory. So like I said, I think that the state's counterplan is going to be very powerful on this topic in a way that it was not on last year's topic, even though states control most of the criminal justice system. It's a little bit different here because states really do control almost all water resources in the United States. There are definitely some exceptions, and I will get to talk about those particular exceptions. The other statistic that I think is important to think about is like 90% of all environmental law enforcement actions, and when I say law enforcement, I mean both civil and criminal, are brought by states. So the EPA is a backstop. The EPA does bring cases against polluters, but especially when states don't have the resources or the expertise, or there's like it's a big multi-state issue. But the vast majority of all environmental law enforcement, whether it's about water or not, or other environmental things, are decided by the states. And the states probably solves like the vast majority of all environmental actions, or at least the state counterplan with unlimited fiat that has become in vogue today. Okay, so the Clean Water Act also applies to non-source pollution or non-point source pollution, and it doesn't regulate it, but it does have things that the federal government would describe as non-regulatory protections for non-point source pollution. This particular picture here is like a picture of non-point source pollution. It's basically runoff from a farm that is, that all of that water that's running off is like full of fertilizers and pesticides, and is probably very harmful for the waterway as a whole. So Section 319 of the Clean Water Act governs non-point source pollution management. And what that does, it doesn't regulate non-point source pollution, but it provides grant funding to states, tribes, and territories, 172 million in 2020, and it provides technical assistance, technology transfer, demonstration projects. So basically, the EPA acts as a clearinghouse where if a state says, we really want to do something to manage, something like agricultural runoff, but we aren't sure about the best way to do it, then the EPA will provide experts. The EPA has scientists. The EPA will do reports. They will provide funding to the state to develop their own management system for non-point source pollution. The EPA might give them or transfer relevant technology. So if there's like new irrigation techniques like precision agriculture that might reduce pesticide management, then that could be something that could be included as part of that grant funding. There's something called the Clean Water State Revolving Fund, which provides loans to states to fund for the construction of sewage treatment plants, stormwater infrastructure, and other water quality projects. And like part of the reason I think that the protection is regulation interpretation of topicality, even though there are like very good cards that say that that is what protection is, like they're just not true. Like that regulations are a form of protection. They're not the only form of protection. And the federal government and the EPA would consider things like building stormwater infrastructure as protection, because like stormwater is a huge source of water pollution. And if you build infrastructure like pipes to capture that stormwater and divert it to places where it doesn't run into the water supply, then that's clearly a form of protection, even though it's not a regulation. So that the funding or technical assistance or technology transfer, demonstration projects, all of that probably counts as protection, even though the negative would dearly wish otherwise. Okay, so the next thing that I'm going to talk about is the Safe Drinking Water Act, which is the other major federal law governing water quality. Okay, so Safe Water Drinking Act, it was passed in 1974 to protect the public drinking water supply. It applies to groundwater as well as surface water. So there is like a big difference between that and the Clean Water Act, because a lot of our groundwater or a lot of our drinking water supply comes from groundwater. How this works, it's definitely very different from the Clean Water Act. So the EPA does develop water quality standards similar to what it does for the Clean Water Act, except that its mandate here is not whether or not you can swim in the water. It's about whether you can drink the water. So it develops, like what is the appropriate level of fecal contamination of drinking water, and like says if it's below a certain threshold, then that's fine. And then it requires treatment of public water supplies. It requires testing and monitoring to ensure water quality within safe levels. So it's not exactly about prevention. The Clean Water Act is about the prevention of pollution within the water supply. The Safe Drinking Water Act is primarily about treatment of pollution within the water supply. So if water quality is down, then public water facilities, like utilities that provide drinking water to the public, they have an obligation to test and monitor their water quality, to treat that water to reduce the level of contamination. If there are lead pipes, for example, that are contaminating the water, like in Flint, Michigan, and also in many other places around the country, that would be governed by the Safe Drinking Water Act, because because if lead contamination in water is too high and harms human health, then they have an obligation to remedy that particular source of pollution. It does have a prevention component. So one unique thing about the Safe Drinking Water Act is that it establishes minimum standards for underground injections of fluid into groundwater. So if somebody's going to inject a bunch of chemicals into the groundwater, the Safe Drinking Water Act regulates that in a very similar manner to how the Clean Water Act functions. Except it doesn't actually apply to fracking, because in the 2005 Energy Policy Act, the Halliburton Corporation, which was the Vice President of the United States at the time, Dick Cheney, was on the board of, they lobbied for an exception to the Energy Policy Act to say that fracking should be exempt from basically EPA regulation of what companies inject into the groundwater. And it's possible that fracking pollutes the groundwater. There is definitely I think a decent topical AF to ban fracking on federal lands. There's in fact at least one solvency advocate that I've seen that says that the Safe Drinking Water Act should apply to fracking on federal lands, and it would claim to probably reduce energy production, because fracking is basically a process where they inject a bunch of water into the ground to create pressure to force up oil and gas out of the ground, but they basically put a bunch of chemicals in the water and then inject it at very high pressure into the ground. And it does release oil and gas and methane, but also potentially pollutes the groundwater. So the Safe Drinking Water Act is enforced in a similar manner as the Clean Water Act. So the EPA establishes standards, it provides technical and financial support, and the states are the ones that are in charge of enforcing it. And then they govern the water supplier itself. So the water supplier is the entity that is responsible for treating and monitoring water quality. The state government is in charge of enforcing it. The state government may send a report to the EPA if they have a problem with somebody who's not really complying, and then it's possible the EPA could also step in. In this instance, so the Safe Drinking Water Act, states and tribes can apply for primacy, which means that if their regulations are as strict as the EPA's regulations, then if their regulations are as strict as the EPA's regulations, then they have primacy, which means that they are the ones that actually do everything related to enforcing the Safe Drinking Water Act. So, for example, Flint, Michigan failed to regulate the levels of lead in that water. The EPA was not directly involved. The EPA established the standards, but Michigan was responsible for the enforcement because Michigan had primacy. And all states and territories except for Wyoming and DC have primacy. And Wyoming and DC, the EPA is actually the primary agent that enforces the law. And there are 4 tribes that are eligible for primacy, but no tribes have actually applied for primacy. If a tribe had primacy, then the EPA would actually treat them like a state, which is an actual legal designation for tribes to be treated as a state. The The EPA will review state reports of violations. They'll provide assistance to public water systems that are not in compliance. So for the most part, the Safe Drinking Water Act is enforced mainly by, the EPA saying, hey, you're out of compliance and do you need help? And then the EPA will provide grants to help somebody, come into compliance. They provide about $100 million a year in grants that it gives to public water suppliers. Public water suppliers are constantly falling in and out of compliance, and the EPA actually, updates their list of what constitutes safe drinking water and the things that are regulated by it every 5 years. So in 5 years from now, they may add new chemicals that are regulated by the Safe Drinking Water Act, and public water systems will have to monitor the presence of those chemicals, and it might require grant funding that the EPA might supply. And then the other thing is that if water systems don't comply, then it is primarily enforced through civil suits. So citizens, if a citizen is just like, hey, there's lead in my water and nobody's doing anything about it, they could sue the water supplier itself, or they could sue the state if the state is in charge of regulating it, which it is under the Safe Drinking Water Act, unless you live in Wyoming. And then they could also sue the EPA, but if the EPA is suing the state for non-compliance, then a citizen can't sue. And that is interesting, because citizen suits is potentially a counterplan against some kinds of regulations, AFs, that there's very good evidence that says that citizen suits are a superior form of environmental enforcement. But if the EPA is taking an active role in enforcement, then that precludes citizen suits from being filed. So it's potentially a way that the negative can interact with some types of regulation affirmatives. Okay, so the last section of the topic that I'm going to talk about is water rights, and I'm just about at an hour now, so I'm going to I'll probably go over about 15 minutes or so, because I do think that water rights are important, and knowing at least a little bit about water rights is important to understand the topic. So I'm going to start by a few definitions of terms. So the public trust doctrine says that surface waters are owned by the people and meant to be protected for public use by the government. The land under a lake is considered public property. So either the state or the federal government owns that land. And even if that lake is on your property itself entirely, the government actually owns the land under it. And the surface waters are meant to be owned by the public for public use. Water rights are the ability to use the water. So when we're talking about regulating overuse or overconsumption of water, we are fundamentally talking about water rights. So it's the ability to use, manage, divert, or sell water. And there are two major types of water rights in the United States that are governed by this chart. So all the states that are in blue are governed by Riparian Doctrine. They're basically states that had plentiful water supplies to begin with. And Riparian Doctrine means that the water rights belong to landowners whose land physically touches the water. So if you have a factory that's next to a lake, you can use that lake or the water within that lake. You can use, if you have a power plant, you can use that water for that power plant, that you have a right to use it. So even though the water is meant for public use, that Riparian Doctrine really means that that the people that have the first priority to that use are the people that are physically connected to the water itself. Somebody that builds something on next to a stream or a river or a lake or on the coast. Prior appropriation doctrine is basically all the states that are in green, or green and orange, which is basically a mixture of prior appropriation and riparian, but mostly prior appropriation. So it applies mostly to the West. And that means that private ownership and access to water is determined by who used it first. So even if you build something next to a lake, if somebody else was using that lake's water for irrigation, even if they lived 30 miles away, they have primary access rights to that water. Their rights come before yours because they were there first. Now, they can't, if they were using it 30 years ago and are still not using it now, then they would not have rights to that. So for prior appropriation to be true, you have to be actually using the water and continually to using the water, and you have to use it for something called beneficial use. So it has to be like for a public purpose, something that is a good purpose. That is, so agriculture, for example, would be considered a beneficial use, and like, the water crisis that exists in the West, because the West doesn't have enough water to begin with. Agriculture is what explains a lot of prior appropriation. Okay, so that's like background terminology. I'm not sure exactly how a lot of this stuff interacts with the topic. The next few slides are like a lot more direct about how they interact with the topic. But I do think that this background information is important for understanding any article that you're reading about water rights or about water use, because an affirmative that regulated water use will in some way implicate one of these concepts at least. Okay, so water rights in the federal government is important. So most of what I've just described, the public trust doctrine and water rights, are almost entirely governed by state law. There are advocates that say there should be a federal public trust doctrine. I think that was like one of the first ideas that I had when I looked at the topic. I found an article advocating it. I don't know how good it is because I still think the state's counterclaim probably solves it. But there are definitely people that say there should be a federal public trust doctrine for water rights. But there are some things that do interact with the topic that are potentially areas for affirmative ground. So federal reserved water rights. The Supreme Court ruled in the case of Winters v. United States, and sometimes called like the Winters Doctrine, that federal land set aside for Native American reservations had rights to water sufficient to fulfill the purposes of that reservation. So that reservation has the right to use that water, if water adjacent to that reservation, or if it had, like, depending upon the water rights doctrine in play in whatever state it exists in, it could be a prior appropriation doctrine. But that reservation has a right to that water, even when those water resources are shared between a reservation and the state that reservation exists in. 1963, the court held that those reserved water rights applied to all federal public lands, and they also apply to federal military bases, that the federal government has the right to essentially prevent states from using that water for purposes that the states want to use it, that they could reserve that water for Native American tribes, for military bases, for national parks, and all of that. And the other important thing to know about this is that the Supreme Court has narrowed that doctrine. So they've basically said that, yes, there are reserved water rights, but those reserved water rights are for limited purposes, like it's for the purposes of a reservation, but it doesn't really define what that purpose means. And the other thing is that claims about federal water rights or federal reserved water rights are adjudicated in state courts, which is crazy to me, but apparently is a thing. Even though it involves an issue of federal law, because there was a law passed in the early 1950s called the Mccarran Amendment, named after a senator from Nevada named Patrick Mccarran, who was like really angry that Nevada had all of these tribal water disputes with tribes, and that they couldn't be resolved in state courts. So he successfully passed a federal law that allowed them to be adjudicated in state courts, as long as the federal government agreed to that. And the court also ruled that, that because tribes contested this, and they said that the tribal water rights claims should be resolved in federal courts, because the Mccarran Amendment only waived the federal government's right to adjudicate those claims in federal courts, but it did not waive tribal rights. And the Supreme Court said, no, in fact, the Mccarran Amendment did waive tribal water rights claims, so they also have to be adjudicated in state courts. So, what does this mean? It means, like, it's possible that you can conceive of protection as protecting water rights or rights to water resources from the claims of state governments. So it could mean that you take an expansive interpretation of tribal rights in terms of how the federal government protects water for tribal uses. And there's a lot of evidence on that. There are a million law reviews that kind of advocate that. You could potentially, advocate for federal water rights to be resolved in federal courts instead of state courts. And I don't know if that's actually topical, but it potentially has some promise. You could argue or overturn a court decision that said that that a national park's access to state water supplies is limited to only very specific park uses, and take a more expansive ecosystem friendly approach to the protection of those water rights for national parks. And the reason why I think all of this is like potentially relevant to the topic is because I do think that affirmatives might be successful in advocating for federal protection of water rights, because water rights are the rights to use water resources. And they potentially have an answer to states' counterplans, and everything that I just described could be easily and probably more appropriately done through the Supreme Court. So as a way that the courts interacts with the topic, I think that this is potentially one way that the affirmative can access this. The other thing that I wanted to talk about as it related to federal water rights is something called Reclamation, or the Department of Interior's Bureau of Reclamation, which only regulates Western states. So this map that you can see up here is the authority of the Bureau of Reclamation. But the main problems of like water use in the United States, or overconsumption of water in the United States, are like basically the Western states plus Florida, because Florida is a terrible state. But reclamation is, I'm sorry, just a second. Okay, sorry, I had somebody at the door. Okay, so the Department of Reclamation is basically the Department of Reclamation. It's part of the Bureau of Reclamation is part of the Department of Interior. It was established by a 1902 law in the Congress, and the goal was to reclaim water in the Western states. So it only applies to the states that are color coded and on this map. So just Western states. And the goal was basically to like help agriculture in the United States. So what does the Bureau of Reclamation do? So it funds projects that relate to irrigation. So it builds dams, it builds irrigation ditches, reservoirs. It has more recently started funding water recycling and conservation projects and issuing grants for desalination projects. And the reason it's like potentially, well, actually, I guess I'll talk about this, is just that the Bureau of Reclamation has an enormous influence on irrigation in the United States. And irrigation is one of the largest, sources of water overconsumption in the United States. It is the largest wholesaler of water in the United States, which means it actually sells the water from the Bureau of Reclamation to agricultural growers. So irrigation, they like pay for the water from the Bureau of Reclamation, and it supplies so much. It's responsible for 60% of the vegetables and 25% of the fruits and nuts in the United States that are supplied through federal irrigation projects. It is also the second largest provider of hydroelectric power, so dams in the United States, behind the U.S. Army Corps of Engineers. In terms of like who builds the dams are also federally regulated by by FERC, the Federal Electricity Regulation Commission. But in terms of like who built the dams, it was the Department of Reclamation. And it's important because reclamation regulates the use of water. So in the same way that the EPA issues permits for for pollution of water, reclamation issues permits that people pay for the use of water. And it means that the federal government has like kind of a direct role in funding irrigation projects that states necessarily don't, can't control this part of the topic as well as they could maybe control the pollution component of the topic, mainly because these are federal projects, and if they receive federal funding, then the federal government regulates the use of that water. And the reality is they do work with the states, so I'm not saying that the states can't resolve this, but I think like the angle for an affirmative trying to develop better irrigation technology or change irrigation over consumption, it does arguably have like an angle on why the federal government is important for this part of the topic. Okay, so the last couple of slides that I have, I wanted to talk a little bit about water use, because I did talk a little bit about water pollution. In terms of water uses in the United States, thermoelectric power is the largest use, but not all of that is freshwater. Irrigation is all about freshwater, is the second largest use. Most of that irrigation comes from the western part of the United States and then also like central Florida. Public drinking water supply is about 12% of those uses. And then industrial is about 5%. And then you can see the like more specific breakdown in terms of this, like how much of it comes from surface water. That's 237 million gallons per day, and how much comes from groundwater, which is 84,700 million gallons per day are used in terms of that. And then you can kind of see the specific breakdown in terms of of how these are all used. And this is all according to the U.S. Geological Survey's water census, in terms of like they were commissioned by Congress to detail how is all water used in the United States. And then this is a map of water scarcity in the United States. So water scarcity is primarily a function of the West, but does happen in different regions. The U.S. does have enough water to meet all of its needs. The US does not have enough water in all of its appropriate areas to meet all of its needs. So California, for example, has a severe water crisis and a severe drought, and that's going to get worse and worse and worse. California's problems, have a lot to do with agriculture. Actually has a lot to do with just like nut production, like pistachios and almonds are things that really are a major source of water overconsumption. So there are 204 watersheds in the United States. A watershed is basically just like all the water in the ecosystem that is supplied to a particular ecosystem. There's a 2019 study that I read that said that 96 of those watersheds are threatened with shortages now, and that and then in 2021, 83 of them have some shortages now. So a shortage means that the rate of that we are withdrawing water from the watershed exceeds the rate of natural replenishment. So it is, threatened with if you're threatened with a shortage, it means that you are coming close to exceeding the rate of natural replenishment. If you have a shortage, then you are exceeding that rate of natural replenishment. By 2071, so 50 years from now, it is likely that 50% of the watersheds in the United States won't meet demand, and that overall freshwater resources will decline by 1/3. Irrigation is the biggest culprit of freshwater scarcity. Like power plants do contribute to it, but power plants also don't exclusively draw from freshwater. Groundwater mining is something that, like in California, they are trying to respond to the problem of a drought and freshwater shortages by just digging deeper into the groundwater. And so there are pistachio farmers who are just like, yeah, we're losing, it's becoming super hard to find more water, so we're going to dig deeper into the ground, take more groundwater out of it, increase the rate at which we're withdrawing groundwater beyond which groundwater can be replenished, because the prices of pistachios are so high that it gives us an economic incentive to make as many as possible. And then climate change and population growth will probably make all of this worse. I did read a statistic that said that every degree of warming would reduce annual water flow of streams and rivers by 6.5%. So all of that is expected to compound. Okay, so I'm mostly done. I've definitely exceeded the time that I intended, but I'm not going to really talk about these affirmatives. There are a lot of things to that I could say about these, and not all of these I think are topical, but these are all things that definitely have solvency advocates that support them. So I could see all of these being affirmatives that are related to the overconsumption of water, that are ways that, depending upon the plan text, could be topical, that could access it. There's a huge body of literature about the energy water nexus. So I feel like, energy apps that regulate power production and potentially claim renewable energy is going to be a pretty large part of the topic. I think that there's a huge body of literature on water consumption taxes. So taxing the water use of like pistachio producers or almond producers, for example, or like the Coca-Cola company in Atlanta, are all probably good ideas that should happen. But I think all of these are potentially things that could arguably fall into the rubric of protection of water resources that relate to water use or water rights. And then I have a second list, which again, I'm not going to talk about, just because of time productions, but this list would probably be affirmatives that are about the first part of the topic. So affirmatives that relate to trying to improve water quality. I think all of these definitely have solvency advocates for them. I think all of these are potentially good asks that arguably have answers to the state's counterplan, and could be definitely affirmatives on the topic. So I hope that you enjoyed the lecture. I think almost 30 minutes over time or 25 minutes over time. So I am going to end now, but I should be able to see you shortly in terms of the live Q&A.